Hello, we are student interns with the Texas A&M School of Law Family and Veterans Advocacy Clinic, and we will be talking to you today about protective orders. What is a protective order? A protective order is an order from the court that protects an applicant from certain behaviors directed at them by another person. The order prohibits an individual from doing certain things to the applicant, including, among other things, committing violence against the applicant, communicating with the applicant, and going within a certain distance, typically 200 yards, of the applicant's home or place of employment.
So there are some common misconceptions about protective orders. And one of them is that they are the same as restraining orders or that they're just pieces of paper that don't mean anything. The second misconception, while technically true, does not mean that a protective order is ineffective. The difference between a protective order and a restraining order is that a protective order is criminally enforceable, while a protective order is civilly enforceable. So what does that mean? That means a person who violates a protective order can be arrested for violating the order. The fear of criminal liability can be a strong deterrent to stop a perpetrator from continuing to harass or abuse someone with a protective order against them. This is not always the case. Some individuals with a protective order against them are unaware that violating the order will lead to an automatic arrest. Sometimes all it takes for the harassment and abuse to stop is for them to get arrested and go to jail. Sometimes individuals do not care if they go to jail. This is why it is important that other forms of relief are included in the protective order. This might include a confidential address or ordering the batterer to enroll in an intervention program. We will further address these forms of relief later in the presentation. There are three types of protective orders: an emergency protective order, a temporary ex parte protective order, and a final protective order. An emergency protective order may be obtained for sexual assault, aggravated sexual assault, stalking, or family violence. These protective orders may be requested by the victim, but they also may be requested by the police or a district attorney. The victim does not have to consent to obtaining an emergency protective order. Therefore, a police officer or a district attorney may do so on the victim's behalf. These are valid for a period of 30 to 90 days, and they do not get extended. These are served on individuals who are in custody. So if the offender has been arrested for the act of violence, they will be served with the emergency order while they are in custody. A temporary ex parte protective order is obtained by completing an application for a protective order. With the application, you must complete an affidavit detailing the reasons why you're requesting a protective order. In this affidavit, you will have to show that there is a clear and present danger. These protective orders serve as a temporary measure of protection during the period prior to obtaining a final order. They are valid typically for 14 days, but they may also be valid for 20. You can obtain an extension of a temporary ex parte order upon request if necessary. This type of protective order requires that the respondent be properly served. Lastly, a final protective order is more of a permanent measure of protection. While it is not actually permanent, they are typically valid for 2 years with the possibility of an extension. These orders may be granted in default. That means if you show up to the hearing and the respondent does not, you can present your case and the judge may still grant the order without the respondent's presence.
How to get a protective order. The first step for obtaining a protective order is determining whether you have a qualifying relationship. There are 4 bases for obtaining a protective order. The family violence basis is controlled by the Texas Family Code, and it requires that the parties be members or former members of a family or household. Obtaining a protective order on the basis of sexual assault, stalking, or human trafficking is controlled by the Texas Code of Criminal Procedure. As previously mentioned, for an emergency protective order, you or a qualifying law enforcement member may request the order. For a temporary ex parte protective order, you need to complete and file an application for a protective order. In this application, you must include an affidavit detailing the events that show a clear and present danger justifying your need for a protective order. With these affidavits, it is best to be as descriptive as possible. you may need to include dates and specific details about the acts of violence that have occurred. Once a judge has granted the temporary order, you have to issue service on the respondent in order for it to be effective. Lastly, a final protective order is issued either upon agreement of the parties or after a hearing. In some cases, the respondent may agree to the protective order. In that case, the respondent agrees to the terms of the protective order, it is signed by the respondent and a judge, and it becomes enforceable. A final protective order may also be granted by a judge following a showing of cause hearing. During this hearing, the applicant presents evidence for their request of a protective order. The respondent, if present, gets a chance to cross-examine the applicant and present their own evidence. If the judge finds that family violence has occurred based on the evidence presented in the hearing, the protective order will be granted. Similarly, if the respondent does not show, or if they default, the applicant will still present their case and the judge will rule based on the evidence presented.
During the 2023 legislative session, two important changes were made to the Texas Family Code with regard to protective orders. Under Texas Family Code Section 85.001, the first provision was an update to the required findings for a protective order. Previously, the requirement was for the court to find that family violence occurred and that it was likely to occur in the future. The statute was amended, however, to remove the likely to occur in the future requirement, and this makes it easier to obtain a protective order. Additionally, Texas Family Code Section 85.002B8 was also added during the 2022 session, and it prohibits a person found to have committed family violence from tracking a protected person or the protected person's family or household member physically or via an application or electronic device. And we're going to discuss this more about tracking and safety measures later in this presentation. So how long does a protective order last? The duration, we've kind of already talked about this during another part of our presentation, but the duration of a protective order will depend on the circumstances and the type of protective order. For a temporary ex parte protective order, the typical duration is 14 or 20 days. This does not mean that once that time period expires, the protection of the order has to end. A temporary protective order can be extended, but the applicant must request that extension from the judge, and the judge has to grant the extension. For a final protective order, the default duration is 2 years. If there is no time period listed in the protective order, the assumption is that it will last for those 2 years. The law permits protective orders for longer than 2 years if there is felony violence, serious bodily injury to the applicant or the applicant's household, or there have been 2 or more previous protective orders and a finding of family violence issued against the respondent.
Next, we will be talking about tips for a protective order hearing. For those who have never attended a court hearing, the idea can be scary and confusing. It is better to know what to expect before the day the hearing arrives. We have gathered a few tips and recommendations to help you on the day of a hearing. First, it is best to have someone attend the hearing with you or drop you off at the front door. Maybe consider taking a rideshare service so that you can arrive directly at the door if no one can attend the hearing with you. Safety on the day of a hearing is extremely important. Second, when you arrive at the courtroom, check in with the bailiff. The courtroom bailiff helps ensure that the courtroom is a safe environment for the judge and those attending. If you are concerned about your safety at all, let the bailiff know. The bailiff can be on alert during the hearing and even help coordinate someone to help you escort you to your car if needed. Third, prepare to talk to the judge about your situation. You may have to testify before the judge about the events you went through. This can be an uncomfortable experience, so knowing that it could occur may help you prepare for the questions that you could be asked. For an ex parte protective order hearing, you do not have to inform your abuser. The purpose of an ex parte protective order is that only one party, you, the applicant, has to be present for the judge to grant the order. The contents of a final protective order. Once you make it through a hearing, you may be wondering what it is that is in the final protective order. This will depend on whether you have agreed to certain terms with the respondent or whether it is ordered by the judge. The final order may include certain prohibitions restricting the respondent from contacting you, possessing your children, whether the abuser will be excluded from the residence, a potential award of property, and whether the abuser has to attend a battering intervention program. What is important to remember is that your final order will be slightly tailored to your circumstances, and it may not look the same as another. An additional side note, if you are the petitioner in a divorce, an active protective order is one of the exceptions to the 60-day waiting period. That means if you are married to the person you are seeking the protective order against, the protective order will allow you to waive the 60-day waiting period for obtaining a divorce after the petition is filed.
So you may be asking yourself, when you've finally gotten a protective order, what's next? So we've compiled some tips for navigating enforcement with the police. So once you have a protective order in place, it is the job of the police to enforce this court order. If the respondent violates the protective order, you can ask the police to help stop the violation. If you are in immediate danger, call 911. If you are not in immediate danger, you can file a report with the police at the police station. If the police are not addressing your concerns, show them your court order. It is important that you show them your court order instead of your application for a protective order, as it carries more weight and shows that you have a current and valid court order. It is also a good idea to keep multiple copies of your order in the event that you need to show a copy to the police. Best practice is to keep one at home, in your car, on your person, and at your place of employment if possible. It is also helpful to memorize the date that the protective order was issued and which page of the order you can find the date and duration. Quickly being able to recall this information will facilitate the process of filing a report with the police. We've also compiled some safety tips concerning social media and the situation that you may currently be in if you're seeking a protective order. Another important thing to remember during this entire process is your overall safety. There are two categories that we're going to address. One is specifically with social media, and the next is concerning tracking devices. So both of these slides focus on keeping your location confidential and not letting your abuser know your current location. So first, be aware of your social media presence. We are often unaware of how easy it is for people to know information about us through our social media. Social media posts can identify your location if you use a geotag to disclose where a picture was taken. In addition, avoid posting any photos that by themselves could indicate your location or places where you could be found regularly. For example, your favorite coffee shop or restaurant. Next, turn off all social media location indicators. Certain social media applications allow you to share your live time location with your friends. Double check that all of these settings are turned off, especially if you have recently updated the app. Finally, consider changing the passcodes to your social media accounts. If you think or suspect that your abuser has access to your social media account passwords, it may be in your best interest to change these passwords. One final note is to not delete any social media posts if you are involved with an active divorce case or suit affecting the parent-child relationship. You are permitted to change your account settings to private if you have a public account, but do not delete any posts, as this could be seen as an attempt to destroy evidence. Moving on to some safety tips about tracking devices. Another way your abuser could track your location is through physical tracking devices or tracking apps on your phone. The most common physical tracking devices are Apple AirTags, as they're relatively cheap and easy to conceal. If you have an iPhone, also make sure that you have reviewed your location settings. The Find My iPhone app can track any Apple devices in the location of your phone. Sometimes it can be important that a friend or a family member who you trust can see your phone's location in case there is an unexpected emergency. But review your settings to make sure that only those you trust have access to this information. Other less known ways to track an individual is through Google apps or other iCloud devices. Google stores much of the information that we access. So if you have any shared Google accounts, try to disconnect those accounts so your recent searches cannot be reviewed.
And finally, we would like to leave you with nationwide, state, and local resources for you to refer back to. On this first slide, we have listed the Texas and Tarrant County resources. These resources offer information on domestic violence and also offer in-person resources such as housing and counseling. Please review these resources when you have the chance, as they could be extremely helpful now or sometime in the future. And this slide has a list of national resources that could be helpful as well. Thank you so much for listening to our presentation about protective orders. We hope that this has been an informative session and that you will be able to use this presentation as a reference in the future. Thank you.